SJC-12467, Commonwealth v. Joshua Rosado.
Ms. McMahon, good morning.
Good morning. For the record, Catherine McMahon, Assistant District Attorney for the Hamden District for the Commonwealth. In this case, the Commonwealth is asking the court to apply Edwards' forfeiture by wrongdoing to a situation in which the defendant allegedly beat his girlfriend, outed her on social media as a rat, posted on social media invitations for people to beat her up if he paid them $200, in an effort to not have her testify in a homicide trial against a third party. She did testify at the homicide trial. That defendant was acquitted. She did testify at the grand jury, which issued an indictment charging this defendant with intimidation of a witness. The Commonwealth's position is that the defendant's acts of intimidation of her for the homicide trial implicated her unwillingness to testify in the trial against him. She says she's no longer afraid of the defendant himself because as of November, she hadn't heard from him for a year, but she expressed fear of what other people might do to her because of what he had posted against her on social media. So this would be an extension of not having a person unavailable for a particular offense, but to a trial of a separate offense that arises out of the intimidation of the witness for the initial offense.
So let's just put aside for a moment whether or not unavailability has even been shown in this case. So the defendant did not procure the witness's unavailability for the pending indictment for intimidation of a witness, correct?
He didn't do anything to her directly for the pending case. No, she hadn't heard from him for about a year.
Okay.
And the year would have predated the indictment.
Okay, so I wanted to just, first of all, make sure we agree on that point. So then, what the judge is doing in order to determine whether or not this defendant procured the witness's unavailability for the purposes of forfeiture by wrongdoing is make a determination of a preliminary question of fact upon which admissibility depends under 104A, law of evidence doesn't apply to that determination, whether or not the defendant in fact procured the witness's unavailability. So you have to show that by preponderance of the evidence.
Yes.
The indictment has to be proven beyond a reasonable doubt.
Yes.
If we adopt your position, have we lowered the standard of proof in every intimidation of a witness case to a preponderance of the evidence?
The jury would have to find that what she said in the grand jury and what she said to the troopers when she was interviewed by them in February of 2017, they'd have to accept those allegations beyond a reasonable doubt.
Good point. Let me rephrase the question. It's a good point. We have lowered the Lattimore standard for the Commonwealth to meet its burden of production to preponderance of the evidence in every intimidation of a witness case where there's a contention of forfeiture by wrongdoing.
I think the jury'd still have to find that hearsay is reliable and it'd have to meet the beyond reasonable doubt standard.
Ms. McCann, I think that's a very good point. So I'm rephrasing my question because that's a good point. Okay, now, the Commonwealth has to meet its burden of production, taking the facts in light most favorable to the Commonwealth. Can a reasonable jury find the defendant guilty? The judge is making a determination under 104A by a preponderance of the evidence that the defendant procured the witness's unavailability. Have we, in every intimidation of a witness case, are we now lowering the burden of production to a preponderance of the evidence?
Well,
you understand my question?
The preponderance is usually a admissibility or production standard. Reasonable doubt is the trial standard.
Right.
What we have here are the text of the Facebook messages, which she authenticated to the police officers and she authenticated to the grand jurors under oath, which corroborate what she says, which provide concrete evidence that at the time that the murder trial was pending, he was putting out on social media that she was a rat and a snitch, and that he was inviting people to attack her for a fee of $200, and that I believe she also testified that he told her to get a restraining order because anytime he saw her, he was going to beat her up.
Could there be an intimidation of a witness case where there wasn't forfeiture by wrongdoing?
If the witness did testify. Some witnesses...
Assuming the witness didn't testify. Is there going to be forfeiture by wrongdoing in every intimidation of a witness case?
In this one, it has to do with physical attacks, outing her to possible danger in the community. In another situation where the person's bribed, it may be different, that we'd want to bring the witness in and have the possibility of contempt to see if they'd be coerced into testifying. Here, I think it would be like adding abuse to the injury already to hold this witness in contempt.
The judge made a finding of intent. That was the
Now,
main...
the motion judge found that at the time that the defendant allegedly made these actions against Ms. Ortiz, he wasn't allegedly intimidating her then, but there's no evidence that he intended to deprive the Commonwealth and
Right, the judge...
of her testimony against him at a future proceeding, which hadn't existed yet.
Right, the judge made a finding that the Commonwealth had failed to establish intent. I'm sorry. What's wrong with using the First Circuit and the Federal Circuit reasonable foreseeability standards to judge intent? What's wrong with using the reasonable foreseeability? I understand the argument that if someone intimidates someone so much that it shouldn't be case-specific, perhaps. But what's wrong with when we look at intent to see what was reasonably foreseeable to see whether or not the Commonwealth has satisfied its burden? Because it is a heavy burden given the Sixth Amendment issue.
It should be a heavy burden. And reasonable foreseeability, I think it was reasonable foreseeable here. He was an acquaintance of the defendant in the homicide trial. He was making efforts with his ex-girlfriend to get her not to testify. She was a percipient witness to the shooting. She was a central witness, not necessarily the only witness in the case, and he made a concerted effort, not only in interactions with her, but to expose her to the community as a rat, that it's reasonably foreseeable that it would intimidate her from testifying against him for his actions around that case.
It becomes more complicated because she, in fact, did testify, notwithstanding those threats, in the murder case and went to the grand jury.
She was in protection, under protective custody at the time that she gave the statement to the troopers and at the time that she testified. She did, in the interview with the troopers, say that she was afraid of leaving the hotel around the time of the trial. So she was protected then. I don't know the circumstances when I think it was presented to the grand jury a couple of months later in April, but she's now out of state, and she expressed to the trial prosecutor and the victim witness advocates that she's afraid to come back to testify because of what was posted about her on social media by the defendant. I add that she also said she was afraid of the defendant in the homicide and his associates. So the defendant's conduct isn't the only thing that has intimidated her, but it is one of the things that has intimidated her. He's exposed her to the world as a rat and a snitch.
Of course, she did testify against him.
She did.
And so has any court, I mean, there are two things you're seeking to do which I've not seen before. One is to say if somebody intimidates somebody to not testify in a case against Mr. Mercado, a third party, and that then becomes a witness intimidation charge against him, that you can then use the intimidation that is the source of the new crime as the basis for forfeiture by wrongdoing. And then the second thing, which I'd never seen before, is where she said, I'm not afraid of him, I'm afraid of others now. Has any court done either of these two? things?
I haven't found anything. What I have found is something that the Commonwealth didn't do here is New Jersey, when it proposed the adoption of forfeiture by wrongdoing in that state in 2009, that would have to also be endorsed by the legislature, and the governor set out a thing where a witness can be physically unavailable because somebody's made their availability, they can't be found, they've been killed, they've been incapacitated. That's one thing. That's not the situation here. We're not contending that we cannot locate her. Another thing is her testimony's unavailable because of the intimidation, and there New Jersey proposed that the witness be brought into court and that be told of the possibility of being held in contempt, and it comes from the witness, like whether he or she is unavailable and whether it's based on the defendant's conduct. That didn't happen here. The prosecutor went with his own affidavit saying that he believed that if brought to court, she would risk being held in contempt. But I think there could be an intermediate step of either making a good faith effort to locate her. I believe she is locatable. If she's not, that's one thing for the motion judge to determine whether the Commonwealth's taken sufficient steps to procure her. And if we can't procure her, putting the witness on the record to say what the circumstance is.
Well, seems important because step one seems to have been skipped in this case, which is as a matter of law, is she unavailable for the purposes of the hearsay exception?
I think the prosecutor was afraid of having her here without extending, if this is an extension, I believe it's an extension of Edwards, to a circumstance where we're not talking about the original case where the person was intimidated, that he didn't want her risk being held in contempt without the application of this expansion of the doctrine to forfeiture by wrongdoing.
Well, that may well be, and it might have been the right thing to do. But as a matter of analyzing this, step one is the witness unavailable as a matter of law before we can get to step two, where the forfeiture by wrongdoing applies.
And the motion judge found that there was, at the time that the defendant allegedly did the acts to this victim, we didn't show that it was with the thought of preventing her from testifying against him for those acts.
Right, and I understand that, but I'm before that. I understand that the judge said, I don't find that the defendant procured her unavailability for the purpose of the pending intimidation of a witness indictment. What I'm saying is, whatever the good reason might have been for the assistant district attorney not to bring the alleged victim back, we don't get to forfeiture by wrongdoing unless there's a determination as a matter of law that the out-of-court declarant is unavailable. You agree with that, don't you?
I agree. So they're either available because in some cases cited here, the defendants had disposed of the victim. That's not or the witness. That's not the case here. It's not a case where the witness has absconded with the help of the defendant and we cannot locate her. The prosecutor knows what state she was in, had contacted the local prosecutor's office, at least to try to get an affidavit from her for purposes of the hearing before the motion judge, and that didn't happen. And only said that he hadn't been able to contact her since the last conversation, which I read as not being able to make telephone contact, not that she's disappeared. And if in the case where a person hasn't disappeared or been disappeared, then I think the step should have been or should be that the witness is procured, brought before a judge, is advised of the possibility of contempt, and says what his or her position is.
Let me ask a question about whether, if the witness was brought in, as you say, and was asked a question she says she's not going to answer, and she says, I'm not going to answer because I'm afraid of him, and doesn't give any, he's a violent person and I'm afraid. Would that be enough? Does there have to be a specific threat to hurt someone because of a specific testimony? potential testimony?
If she, in this case, even if she said, I'm afraid of him, it would still have to be based on the past acts, because apparently there'd been no contact between them from November of 2016 till November of 2017 or so, or maybe February of 2017. So she would have to say, I'm still afraid of him because of what he did. Not,
What if what he did was, there was an abusive relationship, and he didn't say anything about any testimony anywhere? It's just that when he was unhappy with her, he would hit her.
I think under Edwards and the U.S. Supreme Court's case of Giles, and under the rules of evidence, the actions have to be done with the intent to make the witness unavailable or to prevent the person's testimony. So if he was simply an abusive person, and there's no link between that and the possibility of her being a witness, I don't think we can say that the doctrine of forfeiture by wrongdoing applies.
Well, didn't California versus Giles and didn't Justice Souter and Scalia for the court say there may be situations in the context of domestic violence that the level might be so much, going to Justice Budd's point, that it might constitute procuring unavailability?
They said the circumstance of the relationship could be highly relevant. And what we have here is a snippet of their relationship based on what she said to the troopers and to the grand jury about his behavior towards her around the time that she was going to testify in that trial. We don't have the entire history of their relationship. I know that they were not together at the time of the trial. She was staying with his mother, awaiting the hearing when he physically assaulted her. Then she ended up under the protection of the troopers and staying at a hotel. And he was exposing her on social media at that time.
Okay, thank you.
Thank you.
Good morning, Ms. Dame.
Good morning. Michelle Dame for Joshua Rosado. May it please the court. Today I am asking that you affirm the trial judge's ruling denying the Commonwealth's motion to admit in prior statements under the forfeiture by wrongdoing doctrine. This doctrine is a narrow exception to the constitutional right to confront and cross-examine witnesses, and the Commonwealth has the burden of proving three things by preponderance of the evidence, and here they failed to establish all three elements. They first failed to establish that Ms. Ortiz is unavailable. A witness is unavailable if she is absent from a trial and if the statement's proponent, in this case the Commonwealth, has not been able to procure her attendance by process or other reasonable means. However, a witness is not unavailable if she simply refuses to testify. This court must find that the Commonwealth made a good faith effort to locate Ms. Ortiz and to bring her to the Commonwealth to testify. When former testimony is sought to be offered against the accused, as again it is in this case, the degree of good faith and due diligence is greater than what is required in other situations. Here, the Commonwealth served Ms. Ortiz out of state with a subpoena ordering her to appear in the Commonwealth of Massachusetts to testify against Mr. Rosado. They had contact with her as recently as 2 weeks before the trial date, in which she informed them that she would not be there and she was refusing to testify. They knew where to locate her, and they knew where to find her to bring her to Massachusetts to compel her to testify, but they did not do so. The reason they didn't do this was made clear when the prosecutor said he believed that had they done this, she would refuse to testify despite any sort of privilege and rather choose to be in contempt of court. And this is not making someone unavailable. A person is not unavailable when they persist in refusing to testify despite an order to do so. Here, Ms. Ortiz was given an order to appear in Massachusetts. If she came to Massachusetts, she would be ordered to testify, and if she failed to do so, that would not make her unavailable. She is available as a witness, and so that is the first element. Next, the Commonwealth failed to show that Mr. Rosado procured her absence at his trial. As the court said, she has stated that she is not afraid of Mr. Rosado. Who she is afraid of is Mr. Mercado, the individual who she testified at his murder trial for. She, in fact, did testify at 2 separate proceedings after any of this alleged wrongdoing by Mr. Rosado. She testified first at Mr. Mercado's murder trial, and then she testified at the grand jury for this current intimidation of a witness charge that Mr. Rosado faces. There has been nothing since her testimony at the murder trial or her testimony at the grand jury that Mr. Rosado has done to her which has caused her to be absent from his trial. While these Facebook posts that Mr. Rosado allegedly posted about her may have alerted people to her status as a witness for the Commonwealth in this murder case, Ms. Ortiz did that herself when she publicly testified at the murder trial. She alerted everyone to the fact that she was a witness for the Commonwealth in that matter. And so these posts can now not be the basis that she's now refusing to come to Massachusetts to testify when she did in fact testify 2 different times since then.
So those are all very good points. We go to Giles versus California and start with the proposition that you point out that unavailability under 804A does not include within it, under our common law, refusing to testify. Picking back up on the question that Justice Budd asked the Commonwealth, in Giles and in other cases, First Circuit cases and in other circuits, there's been a recognition that someone in a domestic violence situation, the abuse might be at such a level that the would-be witness cannot access the protection of the court or the criminal justice system to such a point that they are unavailable and forfeiture by wrongdoing applies. Justice Scalia talks about this in the majority opinion, and Justice Souter, I think, quite profoundly talks about it in his concurrence. Now, I understand that the judge here did not make the requisite findings for that, but the question is whether or not, based on everything, Facebook and everything else, whether or not there should be a remand to address whether or not that has or hasn't been satisfied. What's your thoughts on that?
There still has to be a showing that he acted with the intent to make her unavailable as a witness against himself. So when federal circuits and the First Circuit has applied this to potential witnesses, it's when it's reasonably foreseeable that an investigation into the defendant will culminate in the bringing of criminal charges. So one example was the United States versus Virgo Montez, when the girlfriend was an informant against the defendant for the DEA, and after she provided information to the DEA, she disappeared. And after her disappearance, there were indictments brought against the defendant. And the court found that this doctrine was applicable because the defendant intended to prevent her from testifying at a trial that was reasonably foreseeable to occur had she continued working with the DEA agents as an informant. Another example with a potential witness where it was reasonably foreseeable was in United States versus Houlihan, when a witness went to the police and made incriminating statements concerning the defendant in a drug conspiracy and a murder. That witness was later murdered, and after his murder, there were charges brought against the defendant. The doctrine was applied because the court found that the defendant believed that the witness was cooperating with officials, that his cooperation could harm the defendant, and therefore could have been foreseen that that witness could become a witness against him, and that the defendant had him killed in order to prevent that from happening.
So you agree that we should adopt, or your suggestion we should adopt the reasonable foreseeable test?
And Massachusetts has never applied it in anything other than conduct that has occurred after a defendant has been charged, but it has been applied through other circuits and other jurisdictions when it is the reasonable foreseeability test.
Do you think we should join those circuits or those jurisdictions?
I don't know if I have a specific opinion on whether we should or shouldn't, but I think at the most that should be where it applies. I don't think it should be extended any farther than when it's reasonably foreseeable.
Won't this mean that if a friend of a defendant who threatens a witness successfully will never, ever be able to be prosecuted for intimidating that witness? Do you know what I mean? Because if this defendant gets away with say she was afraid. Let's assume she was afraid of this defendant here because of what he said about the murder defendant, right? So he can't be prosecuted for that, or he can't successfully be prosecuted for that?
He could be successfully prosecuted if she came to his trial and she testified and she was subject to cross-examination.
But she doesn't want to be found, right? She doesn't want to be found for that reason, but she's not going to come in and tell you that because she's too afraid.
The doctrine wasn't intended to be expanded so broadly that if a defendant intends to make someone not testify as a witness against a third party, then that means that they automatically forfeit their right to be able to confront and cross-examine that witness at his own trial. It should have to be that it is at the least reasonably foreseeable that there would be these criminal charges. And at the time of any of this alleged wrongdoing, there was no investigation into Mr. Rosado. The first time that Ms. Ortiz went to the authorities about what Mr. Rosado was doing was our February 7th interview with the police. There's no evidence of anything that he did to her after that. And at the time of anything that he is accused of doing, there's no suggestion that he was intending to silence her about prior complaints she made about his criminality, information that she had concerning his criminal activities, or any current criminal investigations or proceedings against him. The Commonwealth's theory is that what he was doing was intending to make her not testify against another individual, but that doesn't mean that at the same time he was simultaneously trying to make her unavailable as a witness against himself. And I think what all of the cases that have applied this doctrine have stated that there needs to be an intent that the defendant make the witness unavailable as a witness against him, not against a third party. And if it was to be applied in this situation, it would be a very slippery slope in which there would be any number of cases where the Commonwealth could put forward to the court that a victim is afraid to come into court to testify. In any number of situations where there is an abusive relationship or there is a history of that between the parties, they would never have to produce a live witness for cross-examination at trial. And I think we get to the point that in any intimidation of a witness case, especially, they would never have to produce a live witness, and that is not what this doctrine was intended to be. It was designed to be a narrow exception to the constitutional right to confront and cross-examine witnesses.
So what you're really saying is, to the extent that the United States Supreme Court or circuits have talked about domestic violence and the impact on a victim in general, it's not in the context of intimidation charge based on a third person. So if, let me give you this scenario, the defendant's charged with violating a 209A restraining order, and the alleged victim doesn't show up, and the Commonwealth is able to show at a preliminary hearing the impact of the domestic violence, you're saying, well, whether you agree with that there could be forfeiture but wrongdoing or not in that context, you're saying, well, at least there's a showing that it's the defendant in that case that is facing the testimony of somebody that they allegedly procured the unavailability for that case.
Potentially, yes. Giles was a murder case in which the defendant was on trial for murdering his girlfriend, and the court, that's what they brought up, is they said that if it had been proven that he murdered her with the attempt to isolate her about her prior reports of abuse between them, then this doctrine could be applied. But they also did say that there's not a separate confrontation clause to domestic violence cases, and that's the job of the legislature if they want to carve and discern exceptions with that. But that the court shouldn't be making a separate confrontation clause to domestic violence cases and then one confrontation clause to everything for something else. But I think it would be a difference maybe like in that situation again where it was a murder and they said that had they found that he murdered her to keep her quiet about prior allegations of abuse, but that's not a situation we have here. Because at the time of any of the alleged wrongdoing, there's no suggestion that he was intending to keep her quiet about any history between the two of them. The suggestion is that he was intending to keep her quiet to not testify against a third party. So if there are no further questions, I will rest on my brief.
Okay, thank you.
Thank you.